All rise. The Lawyer of the Apes is now in session. Welcome to episode 1 of Lawyer of the Apes. I just want to go over a few things before we get started on episode 1's topic, which is perjury. Of course, everyone has been going around Twitter with the hashtag Ken Griffin Lied. One of the things that I want to talk about first is that I think a lot of the documentation that is on the internet is being misstated. A lot of people on the internet are saying that the documents that are floating around are leaked documents. That is not true. The documents that are on Twitter, that are popping up on Reddit and other forums are not actually leaked documents. These documents are public record, which makes them even more important. If a document is leaked, it certainly gives an air that it might lack credibility because it's a leaked document. There's really no way to verify it. There's really no way to do due diligence on it. But in this case, that's not true. These documents are public record. And the place where they're accessed from is called PACER. PACER is a federal court website where all documentation related to federal court cases is uploaded. Everything in a federal court case is electronically filed, and this case is no different. So in the January 2021 short squeeze trading litigation, all of the documents are found on PACER. Now, I have a PACER account, so I have access to a lot of the documents. So when I see things pop up on the internet, this is basically where I go to do my due diligence to make sure that these are just not generated documents that are just floating around on Reddit where someone just created it to make it look like Vlad, the little boy from Bulgaria, made it sound like he said something in regards to a conversation with Ken Griffin. Therefore, that forms a hashtag Ken Griffin Lied. Then it turns out that none of it was true. It was all just fabricated and made up stuff. And that leads to the apes losing credibility. In order to maintain our credibility as a community, there really needs to be, due diligence done, not only from a financial point, but also from anything that's posted on the internet. You want to make sure that it's legit before you start sharing it with all of your followers. So basically, when I first started seeing some of these things pop up on the internet, I was hesitant because I wasn't sure where they were coming from. But then once I double checked everything on PACER, and as I'll go over some of it with you guys, it's actually worse than what it looks like in piecemeal on the internet. When you look at it all together, it looks even more damning. The allegations are even more damning against Citadel and Ken Griffin and his possible conversations with Robinhood executives. So basically, PACER, again, is a federal court database that houses documents related to litigation. So basically, this gets updated. This is called the PACER Monitor, and this gets updated every time something new is uploaded. So from now on going forward, anytime something new is uploaded, I will post a video and I'll let you guys know exactly what is going on in regards to the case. Just for today, we're going to talk about perjury, but I will go back in time at one point to describe more aspects of the litigation and what it involves, because I'm going under the assumption that most people don't understand the complexities of the legal system. Now, some of you may, and that's great, but for those that don't, I just want to educate as much as possible. The point of the video is to educate. So basically, in order to start a lawsuit, you need to file what's called a summons. A summons is a document that basically sets forth your allegations, lets the court know what the allegations are against the individuals, sets forth the claims or the causes of action against them, or the counts, that's another word for it, and then asks for damages. So basically, in this case, a summons and complaint was filed, and here's what it looks like. So this is the actual the most recently amended summons and complaint, and it's partially unredacted. So that means some of it is redacted, and the word redacted means basically that some of the information in it is covered up, it's blocked out. And there's various reasons why that could be true. That could be true because some of the allegations have not been proven yet, and therefore you can't disclose certain people's names without some backup for that. And then also the other thing is people need to be protected in terms of addresses and email addresses and information like that because of privacy issues. That stuff has to be redacted or blacked out from the document for obvious reasons. Think about the millions and millions of emails that Ken Griffin and all these other people would get if people had access to their emails. So basically, this is the summons. So it's called the January 2021 Short Squeeze Trading Litigation. This is ultimately seeking a class action, which is basically a group of individuals that are suing. Now, in order to get started in a class action, that you start with a certain number of people. So in this case, there's a number of starter plaintiffs. There's 4 of them that are alleging what happened was a conspiracy. So here I'll show you really fast what the actual claim is. So the claim for relief in this case, there's only one count. It's basically the conspiracy to restrain trade in violation of Section 1 of the Sherman Act, 15 USC number 1, Section 1. So basically, that's the allegation. They're saying that these market makers and Robinhood all colluded together and conspired to restrain trade in violation of the Sherman Act, thereby causing damages to the plaintiffs, and then they're now asking for monetary compensation in return. So, like I said, I'll get into all of that stuff in another video, but for today, I do want to talk about the perjury aspect, because the hashtag Ken Griffin lied is the biggest thing floating around on Twitter right now. And like I said, when you look at it in bits and pieces of just those little images here and there that are floating around the internet, it looks pretty bad. But when you look at it from the perspective of the entire summons and complaint, it actually becomes even more compelling. So let's start off, obviously, this is a large document. There's a 137-page document. So we're not going to go through all 137 pages today, but let's take a look and dive in on the meat of where we get into the possible conversations between Robinhood executives and Citadel executives. So it all basically starts back, starting in paragraph 297 of the complaint on January 20th. Now, again, here's some redacted words. So look, I mean, I'm not going to speculate about whose name's going to the blanks. I'm not going to do a Mad Lib, sort of like Kramer likes to do wherever he sees an article about stocks. He always used to like to throw the word meme stocks in there, even though it has nothing to do with meme stocks. He just likes to, create a stir with everything that he sees to get clicks. So I'm not going to speculate, and I'm not going to fill in the blanks. You guys can use your imagination and figure out whose names go into these blanks. And I don't think it requires too much speculation on your part. So let's start off by looking at each paragraph. For example, on January 2021, someone, the head of executive services for Citadel Securities, so you can figure out who that is and whose name would go into that blank, and Josh Drobnik, the newly hired vice president of corporate relations, agreed to communicate. So there we go. So someone that's the head of executive service for Citadel Securities agreed to communicate with the vice president of corporate relations of Robinhood. So there we go. So there we have a paragraph that clearly states that there was an allegation that there was definitely some type of agreement to communicate between the parties. Now, whether or not that's Ken Griffin or somebody else, we don't know. But we do know that that person is the head of head of execution services for Citadel Securities. So if we did a little more digging, I'm sure we could figure out who that may be, and then we'll be able to fill in that blank. During this communication, this person extended a proposition to Drobnik. Drobnik discussed it with Dan and Lucas, likely Daniel Gallagher and Lucas Moskowitz, Robinhood's chief legal officer and deputy general counsel, respectively, and agreed to revert to so-and-so by early next week at the latest. They responded it was good to reconnect and very happy that they'll be working together. Additionally, Drobnik to just let us know if interested and who the main contact should be. So here they're setting up the initial basis for how they're going to communicate with each other. And then here's an email from Josh Drobnik, the VP of Corporate Relations and Communications, and another person. Again, these are redacted information because this is probably the actual email addresses, which they don't want to reveal. On Monday, January 25th, Drobnik emails and says, "We are on board." Drobnik says Lucas Moskowitz, Robinhood's deputy general counsel, would be the main point of contact. Again, another email here. This sets forth where they say, quick follow-up, we're on board. Lucas Moskowitz, I'm CCing, he'll be the central contact. So there we have some more information. In turn, extends an invitation to Moskowitz to chat. We obviously have a strong relationship between the two firms. Moskowitz arranged a call for 11 a.m. on January 26, 2021. Another email exchange where there's more introductions made between the parties. And then as we go down, we see here that there was an internal Slack chat conversation between Gretchen Howard, Robinhood's chief operating officer, where she informs Vlad that Dan and I are joining Jim at 5 on a call with Citadel. So there we go. We have a allegation that there was definitely a call and a communication with Citadel. Dan and Jim likely refer to Dan Gallagher and Jim Swarwart, president and chief operating officer of Robinhood Securities. Citadel Securities has requested to speak that evening. Howard indicated that she believed Citadel would make demands on limiting payment for order flow. Interesting. As described above, Robinhood makes significant sums from selling order flow, and in particular, selling order flow to Citadel. So this really goes to the conspiracy. We're really starting to see the conspiracy develop between Citadel and Robinhood here in their desire to limit payment for order flow. Tenet muses that maybe this would be a good time for me to chat with Ken Griffin, and tells Howard, you guys can mention that. So again, here we go. So, hashtag Ken Griffin lied. Ken Griffin clearly stated in relation to his testimony before the House of Representatives that when asked if he had any communications with Robinhood, he indicated absolutely not. Based upon the allegations that are made that have yet to be proven, but these are allegations that have yet to be made, that are being made, that was absolutely not true. There was some communication. So here we go. This is the one little snippet that I've seen floating around a lot. But as you can see, when you look at this snippet and then you put it into the context of the entire summons and complaint, you not only see that there's a perjury allegation, but even more important than the perjury allegation is that there is a collusion allegation and that there's a conspiracy going on. Obviously perjury is a serious thing, and I'll get to more into the perjury aspect because that's the point of the video. But really, guys, the collusion and the conspiracy is the real concern here. And these documents and these internal conversations, if proven, are incredibly damning, not only from a civil standpoint, which is this type of case, but also potentially from a criminal standpoint. Shortly thereafter, in an internal chat, Senior Director of Clearing Operations at Robinhood tells Swartwout anecdotal evidence that several large firms are having really bad nights too. Then here's the documentation for that. Swartwout responds, everyone you wouldn't believe the convo we had with Citadel. Again, another assertion, an allegation where there was a conversation with Citadel. More emails go forward. Citadel Securities looking for new Citadel members, informs Swartwout at 9:31 p.m. that the numbers were firming up right now in light of the follow-up conversation between Gallagher and blank. Again, another email. Then at 8:29 p.m., Citadel Securities Vice President of Business Development. Again, the name's redacted, but the position is there. So I'm sure if you just do a quick search, you can find out on LinkedIn who they're talking about. Emailed Robinhood personnel that whom Vlad has met before is available at 10 to speak to Vlad. So someone that is at Citadel that has spoken to and met with Vlad before wants to meet with Vlad again. Because of our partnership, Vlad would like to have a discussion with Ken at some point, just given our relationship, not specific to this crazy issue. So here it seems like, they are saying that it's sort of like a damage control or watch what you say in a phone call conversation or an email conversation, basically saying, oh, no, we're not talking about this, but, we should talk anyway. Swartwout later critically tells, I have to say I'm beyond disappointed in how this went down. It's difficult to have a partnership when these kind of things go down this way. That is an incredibly cryptic and interesting thing that was said. Looking forward to seeing more information and discovery on that. Again, here's the email in relation to that. That gives you a better idea of what the back and forth was. Then they go on to say that high-level employees of Citadel did not only communicate with Robinhood's employees. For example, on January 28th, high-level employees of E-Trade communicated with employees of Citadel to ensure certain orders were canceled. Senior manager for trading operations for E-Trade emailed Citadel about potential open orders, list a number of securities, and asked Citadel if it can confirm you're out on these. Citadel confirmed that several of the orders were canceled. So here we go. We have some allegations and some what will hopefully or be used, that what will be used to establish in court that there was some conspiracy between these parties. So as you can see, guys, when you look at the actual summons and complaint, and it really fleshes out, just these little snippets, and it actually makes things look even worse. But again, I know that, our initial knee-jerk reaction is, of course, to say, this all proves something. But in court, there's certain rules, and rules, require certain things to be identified. And depending on how the statements are made, sometimes they're known as what's called hearsay. And basically, those in court, all of these documents will have to be authenticated, and someone will have to establish that they're true. And then there's certain exceptions to the hearsay rule, which may allow some of the information to come in, even though it was said by other people. And that is all governed by what's called the federal rules of evidence. The federal rules of evidence are a very difficult set of rules that basically limit and set forth how you're able to get certain things into court. So one of the things that you have to do first, if you want to get documentation into evidence during a trial, is you have to authenticate it. So for example, let's say for argument's sake, one of those emails. Now, let's say, a random person from Reddit, says, oh, I saw this email. I have this email from Robinhood, and I think this proves that, Ken Griffin lied. All right, well, let's put this guy on the stand. Sir, do you know where this email came from? Yeah, it's from Robinhood. How do you know that? Well, because it says Robinhood in the email. The court's not going to let that in. Basically, you really need someone to lay a foundation for that document. So basically, you would need an employee from Robinhood to lay the foundation to say that this is a business record. And I'll get into all that in another video. But the point of all of this is that in the court of public opinion, all of these documents on their face are damning. And, apes and everybody can go online on Twitter saying, hashtag Ken Griffin lied. But in terms of proving it in an actual court of law, there is a little bit of higher scrutiny, and there is levels and hurdles to climb in regards to getting this information into evidence and establishing the claim. And again, I'll get into videos on how to establish the entry of evidence in another video, but today we're really just focusing on the perjury. But I did want to mention that to you guys because hearsay and the authentication of documents are very, very important in trials. And again, it's, in a complaint and in a summons, they are just allegations. They still have to be proven. In the United States court system, when you file a civil case against the defendant, the burden is on the plaintiff. That is the person who filed the lawsuit, to prove by a preponderance of the evidence that the defendant was guilty. It does not work the other way around. Citadel and Ken Griffin and all these other market makers do not have to prove a negative, that they did not do something. You have to prove it as a plaintiff that they did conspire. So it's not an easy case. Basically, it's an easier burden of proof in civil cases than it is in criminal cases. In criminal cases, the burden of proof is beyond a reasonable doubt. That means there can be no question that the person is guilty. In civil court, it's a preponderance of the evidence. So basically, it's 50%. If you can establish 50% that they did something, that they conspired, you're going to win. And if it's tied 50-50, just like in baseball, usually the tie goes to the runner. So that's basically that in regards to the rules of evidence for now. So let's talk about perjury. So Ken Griffin appeared before the House of Representatives at a hearing. So there's two different types of perjury. There's perjury under 18 U.S. Code 1621, and there's perjury under 18 U.S. Code 1001. So one of the codes, 1001, is perjury, but perjury for just making any general statement under oath, not under oath. You didn't even have to be under oath. If you make a false statement before a government agency, even if you weren't sworn, you can still get in trouble for making false statements to a government agency, except as otherwise provided in this section. Whoever in any matter within the jurisdiction of the executive, legislative, or judicial branch of government in the United States knowingly and willfully falsifies, conceals, or covers up by any trick, scheme, or device of material defect, makes any material false, fictitious, or fraudulent statement or representation, or makes or uses any false writing or document knowing same to contain materially false, fictitious, or fraudulent statements or entry shall be fined under this title, imprisoned no more than 5 years or so, or if the offense involves international domestic terrorism, blah, blah, blah. That's not really important. So basically, this says that it doesn't matter if you're sworn under oath or not. You can still get in trouble for making a false statement to the government under this code of the United States, U.S. code. Another U.S. code is 1621, perjury. Perjury involves making a statement that is sworn to under oath. And Ken Griffin was sworn in to testify at that hearing. So in his code that he would technically be violating would be 18 U.S. Code 1621. I've seen a lot of Twitter posts, asking for like the state attorney general to file something to seek action against Ken Griffin for lying. It has nothing to do with the state. This was before Congress. So the only people that can put in the request for a perjury charge to be filed by the Department of Justice against Ken Griffin would have to be members of Congress. So you really have to lobby the congressmen if you want them to seek a perjury charge. They have to open up the perjury inquiry against Ken Griffin or anybody for that matter that lies before Congress. It's not up to the states. The section says, whoever having taken an oath before a competent tribunal, officer, or person in any case in which law of the United States authorizes an oath to be administered, that he will testify, declare, depose, or certify truly, or that any written testimony, declaration, deposition, or certificate by him subscribed is true, willfully, and contrary to such oaths, states subscribed to any material matter which he does not believe to be true. In any declaration, certificate, verification, or statement under penalty of perjury, as permitted under Section 1746 of Title 28, United States Code, willfully subscribes as true any material matter which he does not believe to be true, is guilty of perjury, except as otherwise provided by law, be fined under this title or imprisoned not more than 5 years or both. This section is applicable whether the statement or subscription is made with or without the United States. That means within or outside the United States. It doesn't matter where the statement is made. So basically, the penalty for being sworn under oath and for making a statement that's false before a government agency is basically the same penalty. They are both given the same amount of weight in terms of punishment. Now, again, remember, this is not up to the states. This is not a state's decision whether or not to prosecute someone for perjury. It really comes down to Congress. Congress is the ones that has to say, this person lied to us. We want prosecution or an investigation to be opened up about whether or not this person truly lied or not. It's crazy though, because perjury has only 6 people in the last 60 years have been found guilty of perjury. You saw a lot of perjury issues come up during the baseball hearings. Roger Clemens, he was actually charged with perjury and lying to Congress. He was charged with 5 counts of it, and he did not plea it out. He actually took it all the way, and he actually was found not guilty on all 5 charges of perjury. So, and Roger Clemens, if you look back at his testimony, it seems pretty damning on its face. But again, it is a very, very, very difficult standard to prove, because remember, we are not talking about a preponderance of the evidence. That this would be a criminal action, and you'd be talking about beyond a reasonable doubt. And when you're talking about beyond a reasonable doubt, I know it's frustrating, but trust me, you want that standard to be the case, because if anybody is ever in trouble, you don't want them to be able to be found guilty of something by a preponderance of the evidence. It's just very, very damaging. Think about it. O.J. Simpson is another example of how there's a huge difference between the burdens of proof. He was found not guilty in the criminal trial, but he was found guilty in the civil trial in the murder. So basically, he was found not guilty of committing murder, but he was found guilty of wrongful death in the civil trial, which shows you how there's a huge disparity in the burdens of proof and the level needed to establish, whether or not someone is guilty or not. So basically, that is the perjury end of things. Based upon the allegations that were made, in the summons and complaint, again, these are just allegations. Nothing has been proven yet. Are those allegations enough for members of Congress to say, listen, something doesn't look right here. Maybe we should open up an investigation and find out the truth? Yes. I would argue yes. I would say that the Congress should, take a deeper dive into this. If we're all taking a deeper dive into it, where, they're the ones who were wronged by this person. If he lied to them, if he lied to Congress, they're the ones who have standing to say, listen, we're bringing you back in. We need you to clarify some of the statements you made. And then if they double down, sort of like how they've been doubling down on Twitter, then they can open up an investigation into whether or not the allegations are true or not, or whether or not they did perjure themselves. And if they did, then they can request the Department of Justice to conduct a further investigation and then decide whether or not they're going to file charges. But again, based upon the history, people are constantly lying to Congress. And most of the time, the situation is pled out, or they do not prosecute at all. Like I said, only 6 people in 60 years. And trust me, a lot more than 100 people, hundreds of people have lied to Congress over the last 60 years, including members of Congress themselves, I'm sure. But the most recent person that was charged with perjury was lying before Congress was Michael Cohen. And again, that was not prosecuted to the fullest extent. That was also pled out. So guys, basically, I hope this video helped give you a better picture as to the allegations that are being made against the defendants in the litigation that is ongoing against Robinhood and Citadel and other market makers. If the video is interesting to you, please, drop a like down below. And if you have any questions or would like to see anything discussed in more detail, leave a comment in the comment section below. But until then, the Lawyer of the Apes is adjourned.